The recording is on. Today we have Bruce Mack in here from Platinum Trust Group, and also we have Anthony. Of course, you guys have seen Anthony, but y'all don't know if Bruce was coming, so that's what I say for best. I didn't want you guys to know that part. So let me go ahead and give a quick intro. You're in for one of the most informative training I've seen. It's my sincere pleasure to introduce Bruce Mack, co-founder of Platinum Trust Group. He is a licensed financial advisor, nationally known speaker, and author. Bruce is going to put on a training today that is eye-opening and a must for all multifamily investors. He has a proprietary copyrighted trust for asset protection, tax mitigation, and wealth transparency. He is joined today also by Anthony Price, his CPA, who is one of the sharpest CPAs around, who knows the tax implication and the trust inside and out. I am so excited to introduce you both, Anthony and Bruce. Bruce, here you are, you and Anthony.
Thank you very much.
At the mic, and thank you so much for being here today. I truly appreciate that.
Great introduction. Thank you very much.
My pleasure. Now, did you want to turn the screen over to me and I'll get my slides queued up, Susie?
Yes, go ahead. You should be able to share.
Okay, let's see. I want to make sure that I've got this. And this should be full screen. Can everybody see that?
I can see it. I think most of the people are muted. Yes, we can see it.
Okay, it's great. Anthony?
It's loading for me. It's loading for me. There we go.
There it is.
I can see everything. And I would like to start by saying, if anybody has any questions, I'm going to be moderating the comments. So I will be able to answer them live as Bruce goes through the presentation. It is informationally dense. So if any questions come up during the presentation, feel free to drop them in the chat.
And I'm going to just minimize this. There we go. Okay. So I'm going to go through an intense amount of information, guys. Feel free to take notes. I guess Susie's recording this. And let me say this. You're not going to get all of it today, meaning it's not going to all be retained. It's generally a process of a couple of different meetings. First of all, this one. And then secondly, what we're going to do is the offer that we're putting out there is to have a personal one-on-one consultation with Anthony and or myself. And at the end, I'm going to give you a link to be able to do that. And for all of Susie's people, what we're doing today is we are waiving the $250 consultation fee. So it's a chance to one-on-one meet with us so that we can discuss your situation and how our proprietary copyrighted trust might be the ideal solution for you moving forward. I'm a licensed financial advisor. I've been involved with over 160 real estate transactions, $92 million worth of real estate that I've been involved with under my belt over the years, business consultant, speaker, as well as author. And let's just get these slides going. Cue this up. Who is this for? Well, if you're a real estate or crypto investor, etc., and you want to grow your assets with no capital gains. Let me repeat that. That's no capital gains, and or if you have assets that are over $300,000, yes, and are concerned with privacy, which real estate investors that I speak to on a daily basis are always concerned with privacy, then this is absolutely going to be for you. Today, you're going to learn how to exclude and eliminate capital gains in all your real estate transactions and other investments, defer taxes in perpetuity on all your passive income, ensure your assets are kept private, and get ironclad asset protection. Asset protection is a must And just when you think that everything's going great and that you've worked so hard for, you can lose it just like that. I myself got bit and had a $175,000 lawsuit, which was extremely time intensive, that I just didn't need to be involved with and wouldn't have been involved with if way back when I knew what I know now about trusts. So let's start with the building blocks. What's a trust? It's a contract. It's a contract between the grantor, the trustee, and the beneficiaries. It's your rule book, or the government will take control. It's your choice. Now, there are two common types of trusts. One is a testamentary trust, which is created in a will and does not exist while you're alive, and it will require probate, which is a court proceeding. Or you may have heard of, and very possibly many of the people that are on the call today have what's called a living trust. Ours takes all of the elements of a living trust and incorporates them into our proprietary trusts. They exist during your life. They avoid probate, whether they're revocable or irrevocable. Our revocable trusts, unfortunately, not our, but revocable trusts as a group, do not have asset protection. And that's the standard type of trust that people have. In a living trust, it is a revocable trust, and therefore it can't offer asset protection. Versus our trust, it's an irrevocable trust, and they can, by definition, have asset protection if they're structured properly, like our trust. This is a very important chart because it really, as I call it, hits the rubber where the road meet. And as you can see, whether you have a C or an S Corp or an LLC, which is the common structure that we find that most real estate investors have, or you have a holding company, or you have a land trust, or you have a living will or a living trust, as you can see, they do not have the ability to eliminate capital gains. And with our Platinum Trust, we do. Deferring on income tax, they don't, we do. The ability to avoid lawsuits, they don't, we do. The ability to also avoid judgments, liens reaching the business, again, that's where we win, and the others just don't have the capacity. Avoiding probate upon death. Well, there are a couple of yeses there. If you do have a living trust, that's why you got it, was to eliminate probate, and ours does as well. We have the ability to avoid gift tax, avoid estate tax, ensure that the beneficiary's assets transfer properly. It is truly a multi-generational wealth accumulation tool, and we avoid annual fees. So you can see that our trust, when compared with the other types of structures out there, is really quite different. So I want to break this up really into two sections. First of all, we'll talk about asset protection, and then we'll circle back around and we'll talk about tax mitigation. Corporations and LLCs, unfortunately, they just don't protect you, and they're likely the entity that you currently have, because most real estate investors are either what I call partnerpreneurs or they are solopreneurs. And as such, they are perfect sitting ducks for somebody who wants to litigate against them and pierce the corporate veil. And it's easy to pierce the corporate veil because the allegation that is made consistently is alter ego, meaning that you are, because it is a closely held entity, you are trying to exercise dominion over your entity because it's you controlling you, and it's the winner. These are also arguments that are easily made. Insufficient corporate separateness is a biggie. They'll use that to pierce the corporate veil, and it's very, very successful. I'm going to show you a slide just how successful it is. It's scary when you see what the real story is. And again, these all talk about alter ego, inadequate. These are other ways that can also pierce the corporate veil that they could allege. This is a big slide. This was a Wake Forest Law Review study that was done, and the study revealed that they were able to pierce the corporate veil 39% of the time when the case was alleged in district court or state court, and over 41% of the time when it was alleged and it was taken to federal court, utilizing the alter ego approach. So here we are, almost 50% of the time, you're a sitting duck to have your corporate veil pierced if you have an LLC, a C, or an S. This is just not the case with our trust. There's never been a properly constructed trust with the provisions that we have in it that has ever been pierced. There's one exception, and I will share that exception with you as we go through the slides. And this is even potentially worse. Lawsuits against you personally, if you're the plaintiff, damages can be recovered by utilizing what's called reverse veil piercing. Now, most people aren't aware of this. This is a newer strategy that has been created to pierce the corporate veil. So let's just say you had a $2 million award against you. You only had $1 million in the LLC that they went after. Well, guess what? You've been taught to segregate and put your properties into separate LLCs. Well, this gives the court the right to go into those other LLCs to be able to get full satisfaction of what's called judgment. So you could lose everything by them just going after LLC after LLC after LLC to completely wipe you out, utilizing reverse veil piercing. Entity stacking, which we've heard about before, maybe things like utilizing multiple LLCs and or utilizing holding companies as additional levels of protection. They are an additional hoop to jump through, but realistically, once you get through those, you get the same ability to go after the heart of the matter and get to getting a satisfaction of judgment against you and getting potentially completely wiped out, which we would never want to happen. Also, you could be opening up the door for multiple taxation in multiple states. I submit to you that many of you have been taught, well, you have a property in, I don't know, Chicago, and you live in Atlanta. And you've been taught, no problem, that you get a Illinois entity, and that's great. But the fact is, you live in Atlanta, you also need to get what's called a foreign filed entity to be completely, if you will, compliant and not have all kinds of additional taxes because you did not file the foreign entity. And that would be also potentially be used against you in a court of law to pierce the corporate veil. In California, entities are extremely costly. They're $830 annually. So if you don't do a foreign filing in California, if you've got properties that are out of state, but you did a filing to get an LLC for them, you could be hit for $12,000 per year for each one that you didn't file. Again, why would you want to create excessive expenses when there's a better solution, which we're going to be discussing? So we talk about our trust. It has many, many different provisions in it. These are a few of the leading provisions. The fact that it is truly a dynasty trust, meaning it is a multi-generational wealth transference tool, non-grantor, irrevocable, discretionary, complex, spendthrift, not self-settled. It has a HEMS provision, crummy provision, and many other provisions as well. This slide really talks about the fact that if you do fulfill your filial responsibilities, quite literally, Somebody could come after you. If you have a trust, that can't be the case. And this is something that we've seen where a guy that we know about got wiped out when he found his checking account $93,000 light because a hospital came after him for family charges that weren't even his. Bad situation. Again, the type of thing that could happen if you don't have a trust. Statistically, there are over 109,000 lawsuits filed each and every day in the United States, a staggering amount. And another figure to be aware of, the average business lawsuit is over $70,000. So these things become very expensive very quickly. 91,000 PI lawyers could be one of the main reasons that there's so many of these lawsuits filed, because there's so many of these guys that are constantly looking for a new case to be able to represent and potentially do profit sharing if they took it on contingency. Statistically, slip and falls are the number one problem that you face, and there are 25,000 of these filed on a daily basis. We're talking about slip and falls, and they increase on an annualized basis, and certainly they also increase significantly as we see economies suffer. This guy would have never been subjugated to this $150,000 bill that he had to pay, because the business owner was sued by the contractor who was doing work that wasn't even to code. But he was able to hit a bingo, which was crazy, which would have never happened if he would have had a trust. Now, many of you have heard about some outrageous claims. One of them was the hot coffee spill. It was pretty infamous, where the gal got hot coffee spilled on her, sued McDonald's, and won a $3 million suit. Well, the fact was, and this is something that most people are not aware of, 2.7 of the $3 million was a punitive damage award. So you may have coverage. You may even have personal insurance in the form of a $1 million or multi-million-dollar umbrella. But one thing I can tell you, having looked at countless amount of insurance coverages, there's never been an insurance coverage, even an umbrella, that covers for punitive damages. And punitive damages can be the most significant amount of an award. Other types of claims that could come at you: asbestos claims, lead-based paint, certainly mold issues. All of these are unfortunate realities that real estate investors have to deal with, and having a trust protects you, insulates you, and isolates you against these types of claims, resulting in a lien, levy, or judgment. Real estate investors can also be charged and classified as a dealer. And this is something that I've seen over the years. The IRS's definition of a dealer is one who is looking or is doing an investment for and purchasing a property for making a profit. Well, my gosh, why would you buy a property without the intent to make a profit? That's the name of the game, right? The unfortunate reality is flippers are the ones that usually get hung with dealer status, if you do. And let me show you what this means. The potential of having 50% plus of your payday taken away because of the Medicare surtax, the alternative minimum tax, the 15.3% of self-employment tax. It's horrible. And you also, for exit strategies, don't have the ability to do 1031, self-directed IRAs, or other seller financing. So what we are not We are not subjected to tax liens, levies issued against beneficiaries or trustees, divorce and alimony, child support, creditors, governmental agencies, or third-party claims, or subjects to the court's jurisdiction over orders, except for fraudulent conveyance. Remember, I told you a few minutes ago, there was one exception when you get a trust, and that's potentially fraudulent conveyance. Let me give you an example of fraudulent conveyance. Let's just say you'd been served with a lawsuit and you had heard about a trust that is magical and can protect your assets, our type of trust, and then you get our type of trust. The unfortunate reality is that the court could create a motion to set the trust aside because you knew that you had been sued and you were utilizing it to try and protect your assets. So when is the best time to get a trust? I always tell people today, because you never know what might happen tomorrow. Properties can't be seized when you have a properly constructed trust like ours. And here's the case law that supports that. Trust is not a person. And this is very interesting in as much as our trust is a contract and therefore is not recognized as a person. And therefore it's a specialized trust that cannot be sued. It has to be set aside unless fraudulent conveyance can be proven. Now, we had a client, this client's son, 17 years old, got into a very severe lawsuit. The opposing counsel was coming after him for a over 6 or 7 figures $1 million lawsuit. Matt called the guy up, and what do you know? He informed him about his trust, and the guy never called again. It was that simple. So this can be a very, very tragic situation if you don't have a trust, because obviously kids that are under 18, you're responsible for, and they could quite literally wipe you out. I've seen it happen before, and this is a protective mechanism to keep it from ever happening to you or yours. So let's switch gears. Told you we would move into talking about tax mitigation, and we're going to walk through how to avoid capital gains and also your income that is of other types as we roll along. So stay tuned. So in a time of transition, there could be an increase in federal capital gains, income tax. We have heard about also a reduction on the state taxes, which are currently, I believe, Anthony, aren't they right now about 13?
It's about 11.7 million per spouse currently, which is set to go return to 6.2 million upon the expiration of the Tax Cut and Jobs Act, which will be 2025.
Thank you. So guys, I just met with somebody 2 days ago, and he's got an apartment building. I'm in LA. He's got an apartment building that he picked up from his dad, and the damn apartment building, they have an offer on it for $25 million. He doesn't know what to do. I mean, he does now, and we're going to get him a trust, but he's single, he's in his 80s, and he's got a child and grandkids, and he wants them to be able to not have the estate quite literally on that money's over the 11.7 million. He's looking at 55% taxation, and his state getting decimated if he doesn't react and get the property into a trust. So this is what he's going to do. And this could be, again, a solution for you. And on a going forward basis, as these things radically change on a yearly basis, you don't want to get caught where the caps are reduced. You have a higher worth of your estate, and your heirs get completely clocked. And again, we've heard about capital gains cap of $500,000. I just don't know where that's going to go. But if it does, that could really, really hurt a lot of folks as well. Here's Janet Yellen, and she talks about reporting crypto transfers. There's all kinds of things in the brew. What is the impact of Prop 19? Susie, are there people on from California?
Sorry,
That's
you asking
okay.
if is there people here from California? I wouldn't know because I don't ask them for,
Then I'm going to quickly run through this.
yes, go
Just
ahead.
in case there are. If you transfer, Proposition 19 has been horrible, and it has created a big problem for California residents that want to downstream their properties to their children, commercial or residential, in as much as they are reassessing. So somebody who might have had a property for 10, 20, 30 years, and then we had this huge boom in the real estate market, the kids are getting clocked on the transfer. We have a solution, as you can see, at 1.25%, which is the average county assessor's fees per $1 million. For increase, that's 12,500, or for $10 million portfolio would be an additional $125,000 a year. We have a way to circumnavigate that by utilizing our trust. So if you are a California resident, and this is something that is of course concerning, you'll absolutely want to get a consultation so we can discuss this in more depth and be able to eradicate your falling into this horrible, horrible trap. Medi-Cal and or Medicare is something else that people are very concerned about, and they should be, because if mom or dad or your wife or your husband needs Medi-Cal or Medicaid, depending upon the state, there's in most cases, and again, this is state dependent, but in most cases, there's a 5-year look back. Well, with us, if you need those services, and what I mean by 5-year look back, that means that they're going to go back 5 years. You'll have to fill out a form, and what they will do is they will take all your assets, if you have income and or income more than, in most cases, again, state dependent, $1,700 a month. So I see them taking houses. I see them taking full estates to be able to pay the bill that's being created. And this is something that can completely decimate a state, and something that when you get a trust, they're not allowed to be disclosed. And therefore, again, I won't say in every state, but in every state I can think of, we are able to circumnavigate the 5-year look back. Again, we can take a deeper dive depending upon what your situation is. We have the ability to legally reduce taxes by roughly 78 to 97%. So this is huge. We are able to move them into what we call a going forward, or into a deferred status until the trust distributes. What do we mean by that? Well, as I said earlier, we have a dynasty trust. It's a multi-generational wealth transference tool, and it's meant to inure or stay in force until it distributes. So let's talk about the distribution characteristics of the trust. The trust will distribute 21 years to the day after the last sole surviving heir to the last sole surviving beneficiary deceases. Well, that means that the trust really was meant to last hundreds and hundreds of years. Of course, we don't know when that last person in your family tree is going to die, but it's really inconsequential, which starts that 21-year clock, and then the distribution that happens. But when the trust does distribute, one thing is for certain: everybody that's affiliated or associated with your family tree, they have to be dead, and they have to be dead and have passed on 21 years ago. So if there is any tax that has been deferred until that time, that's fine. IRS can go into the estate, but nobody has to personally pay that out of pocket, which is a beautiful thing. Let's talk about the Kennedys for a moment. This is a reprint from an article from Forbes magazine that was created back in 2014. And right in that article, it said, capital gains taxes could potentially be deferred for forever. So right in Forbes, talking about a dynasty trust, talking about the Kennedy family, and therefore, as you can see, this whole notion of capital gains treatment is not something that's new. It may be new to you today, but it's certainly not new to people like the Kennedy family. And the Rockefellers, there was a follow-up article in Forbes magazine a couple of years later that talked about the fact that a lot of the reason, the key and central focal reason of the Rockefeller state staying intact was due to the implementation of trusts. We believe in full transparency, whether it's your business income tax return, trust income tax return, personal income tax return. When we do returns and we have a full accounting staff, we have full bookkeeping, we have fractional CFO services. So we have a full, if you will, complement of people that are on the team to take care of people, get them up and running with their trusts. But we fully disclose everything on tax returns. That's just who we are, how we operate, utilizing the various tax codes that we have to be able to get the great results. Now, none of the tax professionals we work with, having prepared countless thousands of returns, have ever been audited. We actually, since this slide was created, we did have a client go through an audit a couple of months ago. They were pulled for audit for 2017. That person owns over 100 single-family residences. The outcome of the audit was very interesting. When she got into the audit, they also, after they were in the wrap-up stage, said, you know what, let's take a look at 2018 and 2019. Well, 2019 was the year that she got her trust. So the trust was brought into the audit, which was a good thing, because at the end of the audit, it was found that there was no change, which is the best possible outcome that one could hope for. So she went through the audit, didn't have to pay a dime. Our trust was brought into the equation, and it was a win-win scenario. Tax avoidance is legal. We would never ascribe to tax evasion because it is illegal. The Department of Treasury shows the special agent handbook says any attempt to reduce, minimize, or alleviate taxes by legitimate means is permissible. And certainly the means that we use are completely legitimate. How the IRS works. This slide talks about the fact that there's nothing to lose, much to gain, because there's a big misconception amongst taxpayers regarding how the IRS really works, other than tax evasion, fraud, and failure to file income tax returns and incorrect tax position taken in good faith is not criminal. People don't realize that. And we actually have on our team not only CPAs, EAs, which are enrolled agents. Well, of course, Anthony is a CPA, a highly trained one, but we also have tax attorneys and tax attorneys with LLMs, which are like a PhD in tax, and tax attorneys with LLMs that are admitted to the tax bar, who will all back up this position. In district court, federal claims, the The findings were disputed tax liabilities must be paid first before cases can be heard. There have never been any cases regarding our trusts. Same thing, no cases regarding our trust. We have a win-win track record. We're A+15 rated in the Better Business Bureau. This is just how we fly. Legal case rulings on this Edison course ruled that persons may adopt any lawful means for the lessening and the burden of income taxes. And in the Weeks versus Sibley case ruled, and yes, we do have a spendthrift provision, that it's not illegal if formed for the express even if formed for the express purpose of reducing or deferring taxes. A staggering statistic, Jeff Bezos several years ago actually got a $160 million refund on $11 million worth of profits. Why do I bring this up? And why do I bring this slide up? I bring these slides up to point out that with good tax advice, great people who know what the heck they're doing, they can navigate the tax choppy waters and end up with potentially a minimal or even a zero tax consequence, which is exactly what we're looking to accomplish for you and your business and your lifestyle, as well as your downstream heirs. What do these millionaires have in common? They all have trusts. Matter of fact, even Camilla Harris keeps her assets in a tax advantage trust. So again, trusts are more recognized by the elite, but our trust is not only great for the elite, it's great for the common person that has our trust. We have people everywhere from several $100,000 worth of assets to hundreds. We have a client currently that has a $400 million estate. So there and everything in between. The history of our trust, they started way back in the 90s. We currently have over 40,000 clients that have this type of compliant trusts. These are where some of the trust tax laws come from. What makes our trust unique is the fact that we have all these types of provisions and more, that these are just some of the major provisions that we have. And the fact that the spendthrift provision, there's never been one, like I said, that has been properly constructed that has ever been able to be penetrated. Again, more on the spendthrift provision, designed for the benefit of the beneficiaries. Beneficiaries' expenses paid from the trust bank account to a third party are considered to be trust expenses, and money paid to beneficiaries directly is a taxable distribution, other than the fact we just had a rewrite on our trust. And Anthony, hopefully you're seeing that chat group. I'm seeing there's a bunch of people asking questions, and I know you're getting back to them. Just wanted to give you a heads up. Money paid to beneficiaries directly is a taxable distribution unless it's part of Crumney provision, which gives the ability to do a $16,000 distribution to anybody who's a beneficiary of your trust without it being a taxable distribution. But let me frame this for you. There's two ways you could have your trust do a transaction. Let's take a college tuition for one of your kids and buying a car. Well, you can give them the money, $20,000 or whatever for the tuition, and tell them to go down to the admissions office and pay it. And that would be a K-1 event. It would be a taxable distribution to your beneficiary. But doing it the trust way, where you have a $20,000 bill that needs to get paid, and instead of giving that to your child, putting it in and having them put it in their account and then paying the Office of Admissions, you just pay the Office of Admissions directly, because it's a trust expense and therefore there is no taxable distribution. Same thing with your child you want to buy a car for. If you just pay the car dealer directly, as opposed to giving them the money and telling them to go down and pick out their car that they of their choice, then you have a trust expense as opposed to a taxable distribution. Part of the training process that we go through with our clients is we have 2 times a week meetings, Wednesdays, Fridays at noon, where any kinds of questions can be asked. If you can't attend for any reason, you can send in any question. It will get covered on the first part of the meeting, and then open floor questions at the tail end of the meeting. All of these meetings are rendered into podcasts within 24 hours. So you can go in and receive the podcast, and you can, as you're driving or you're sitting in a place where you can listen to the podcast, great. It's also turned into a transcript. So if you'd rather read the meetings, that's fine too. My point is, we give exceptional backup and support. You'll also be assigned to a trust advisor who will help and guide you and work with you to get your trust set up so that everything is intact and working like a clock. You also get assigned to one of our tax professionals who will give a consultation and go over globally what needs to happen, and will then also be working with you to do your tax return for your trust. So these are all things that are receivables that when we get to the proposal stage, should you want a proposal, will be articulated as in terms of deliverables for you and your trust. This is the rule that we use, 643A3 specifically, that gives us the ability to do the deferral on taxes. So you may be getting distributions, quarterly distributions from syndications that you're involved in, or you may have rental properties that you have on your own where you're collecting monthly rents. Those are all considered to be what we call passive income, and all passive income has the ability to be deferred in perpetuity, meaning, again, not until that trust distribute, which is likely going to be hundreds of years from now. Let's talk about home expenses, third from the bottom, to give you an idea, showing you on that middle column, traditional tax, if you will, exemptions or deferrals versus the trust, which, as you can see, instead of having mostly all zeros, 100%. So trust expenses for your home, because you're the trustee, can be things like, well, instead of just the interest portion of the mortgage, the entire mortgage payment. If you have a domestic that comes in and cleans, the entire bill that you're presented with for your monthly cleaning bill from the person that comes in and cleans. If you have a pool, your pool maintenance person. If you have landscaper that comes in, the entire landscape architect bill or the gardener bill, call it what you will, depending upon who they are. All of the insurances that you pay for the house, the property tax that you pay for the house, repair and replacement for all furnishings that you have for the house. Heck, you might even do a several $100,000 remodel. It doesn't matter. These are all trust expenses, and this gives you just a quick peek inside the box as to how great the trust, if you will, expense opportunity is. That's huge versus how minimal the expenses that you can write off if you don't have a trust. How do I fund the trust? We fund the trust by creating what we call a demand note, which is selling and conveying your assets, which is very simple. We can work with you remotely. We even have licensed document preparers on our team to help you through the process of getting everything sold to the trust. And in consideration of sale, whether it's personal property, including jewelry and or fine art, and or it's it's considered to be real property where it's sold at basis, does not create a tax burden for you at all. There are no taxes because of the way we do the conveyance and sales of the property. Yet you get back in exchange a big fat IOU from the trust to you personally that you can use and tap at any time for personal expenses. There are only 3 expenses that the other side of the trust, where you are collecting your rent and lease income and where you're collecting capital gains that you're not going to be paying going forward, that would create a taxable distribution. And they are what we call the 3 Fs. They are personal food, personal fun, and personal fashion. So if it's not personal food, fun, or fashion, then you use your demand note, which is going to be a large sum of money, hundreds of thousands, likely maybe even millions of dollars, and you can use that, and therefore there's no taxable distribution. There's also exceptions to the taxable distribution component on the other side of the trust. And let's say you've got kids that are under the age of 21. They are entitled to, or I should say, you are entitled to 100% trust trust expense of 100% of their clothing bill, including Nikes, and 100% of their food until age 21. So this is another huge, if you will, benefit of having the trust. So how do you fund the trust? Rent and lease income, the properties that you own, personal houses, jet skis, gems, anything and everything of an assetable value will go into the trust, and you'll get that IOU from the trust back to you. How do I get money out of the trust? Simple. You have a trust bank account. You write a check, or you have a check card, a bank card, or you use credit cards that you personally have, and we will show you how to assign those to the trust so that at the end of the month, it's super simple to keep the books. So whether you want to buy a brand new Porsche, a new house, yachts, it doesn't make any difference. These are all legitimate trust expenses. Remember, I said you can use trust assets for anything. There's only 3 potential taxable events: is if you're utilizing the money that's coming in from rent and lease income, and money that's coming in from the distributions that you may be getting on syndications, and or capital gains that could create a taxable event. And that's if you use it for personal food, fun, or fashion. But utilizing it for investments, utilizing it for boats, utilizing it for RVs, utilizing it for anything else is not considered a taxable distribution. Okay, so we're in a wrap up here. There are no seizures on demand notes, so nobody can come and knock on your door and take your demand note. It is completely isolated and insulated against liens, levies, or judgments. Again, a guy I know, he ended up having to pay a $250,000 reward out of his back pocket, even though he had $1 million+ umbrella. I lost $175,000 because we're running short on time. I'm not going to go into the specifics, but it was tragic because it didn't need to happen, because I had an LLC at that time and I didn't have a trust, and it cost me a lot of money, and it doesn't need to happen to you. Assets in the trust, there's 0 capital gains, whether it's stocks or bonds or currency or Bitcoin or crypto, or selling assets to another trust, or real estate acquisitions, which many of you guys are involved in, buying or selling of businesses, which you may have an ancillary business, you may have a car wash, you may have a dental practice. I don't know, but it makes no difference. If you're selling a business, it's going to generate capital gains. And if you have the business in the trust, which is exactly where you want it to be for asset protection purposes, when you sell that business, you're not going to incur capital gains. There are no federal or state probate problems or no gift tax that you have to get roped into. Zero capital gains on the growth or sale of trust-owned assets. The sale of assets to the trust are non-taxable events. There's no cap on the amount of assets that you can sell to your trust. And pursuant to IRC 643, capital gains and or losses or exchange of capital assets shall be excluded to the extent such gains are allocated to corpus. So here's the actual IRS code section that we ascribe to, so that you never would want to do a 1031 exchange again. Why would you? It's a not liquid asset. So you can be selling your properties, or if you have properties that you've put into 1031 exchanges from past transactions that you've done, yes, you can now list them for sale. You can sell them. You can, first of all, put them into trust, then get them up for sale. And all the taxes that had accrued from the previous 1031s that you rolled into, all of that will be treated pursuant to 643A3 ergo. The capital gains will absolutely be excluded, which is exactly where I know you want to be and can be. So I always like to ask the question, what do you think your future would look like if you were able to control what you earn? Which, of course, if you've got a trust, that's the exact position that you will be in. So the trust package includes all of these components plus more. We don't have the time to go into all of this because we want to pick up a question or two as we're in wrap up, but this is the most important slide. Take out your camera and take a picture of this, because this is Anthony's direct contact number. And for booking an appointment from this webinar, you want to go to anthony.platinumtrustgroup.com, or we're giving you right here Anthony's direct line, the 208-277-7733 number. So Anthony's number once again is 208-277-7733. So that's the wrap up to be able to get your one-on-one consultation, so we can give you the important information. So hopefully you'll get started with the trust right away. Susie, let me turn it back over to you. I want to thank you very, very much for you giving us the opportunity to be able to get this important information to the folks that you work with.
Bruce, thank you so much, you and Anthony, but there is a question in the chat so far.
Sure.
I think Crystal has that question. She asked, she said, I've also heard that a parent can give their child up to $1,000 per month to pay them for working on their businesses as a write-off. Is that correct?
That is correct.
So the question is about paying your children, compensating your children in the business. And the answer would be that if they provide actual services that you are compensating them reasonably for, you absolutely can take the write-off. Now, of course, there have to be actual services that they're providing, and the compensation has to be reasonable in the circumstances. So if they do half an hour of work a month, right, it's a little bit unreasonable to compensate them $1,000 a month. But if they provide 5 hours a week, you could potentially have them a little bit higher on the payroll and pay them $1,000 a month. Now, the benefit to this is when they're your child and they're under 18 years old, you do not have to file a W-2, and therefore you do not have to collect any payroll related taxes. It's a deduction to your business, and because it's under the standard deduction of $12,950, and of course it changes every year, when it's under that total, then the child will also not pay any taxes either. So even if you use the funds that you paid them in maybe a joint bank account to pay for expenses that you were already going to pay for them anyway, but you were able to structure it under your business as a deduction for compensation for services that they provided, you can absolutely pay your children and you can get significant tax benefits for doing so.
Like I told you guys, Anthony is a wizard. He knows his tax stuff. So you are very, very lucky to have an opportunity to get this one-on-one. I mean, normally when you go to a CPA, let alone just a basic tax preparer, you're going to be paying several hundred, $200-300 or more dollars an hour for this kind of knowledge. And this is why you want to book with Anthony and get that complimentary consultation. Thanks, Anthony. Great answer. Great follow-up.
Thank you, Anthony.
Yeah,
Thanks, guys.
somebody has a question. Funds, Merville has a question.
Hi, Anthony. Thank you. A great presentation and probably very informative.
Thank you.
My question will be a follow-up to the question pertaining to Charles, a deduction that can be done, like the $1,000 thing. How is the process? Or how does the process go? Do you have to have an LLC or an S corporation, or do you have to provide it a check or cash? How does it go?
So it completely depends if it's done out of an LLC or out of maybe your sole proprietorship. You don't even have a LLC in any particular state, then you can pay directly through transfers from your business bank account to the personal bank account of the child employee. Now, when you have an S corporation, there is a requirement to file a W-2. So the best practice for paying your children is actually going to be through a single member LLC or through a sole proprietorship. Maybe you would call it a family management company. But when you pay your children, you either pay them through distribution from your business bank account to personal bank account, or in the case of an S corporation, you would then process payroll and therefore collect payroll taxes to pay your children.
Now,
So,
does that cancel the child credit?
It does not cancel the child tax credit, no.
Anthony, can I jump in here? It looks like we're going down a rabbit hole. That rabbit hole is to try and get a deduction to minimize the taxes. But Anthony, would you not agree that if somebody sets up their trust properly, that this is really an inconsequential amount of savings, because the trust is going to get them into 97 in the high 90s and or more in terms of tax mitigation through the deferral and the elimination of capital gains taxes. This is the type of questions that I'm hearing with the child, paying the child and trying to get some deductions is generally not a topic that even comes up when you have a trust, because you get such fabulous tax advantages. Am I wrong, or what do you think, Anthony? Let's get some input.
I'd say you're correct. It was a good question for business deductions, but what's the most material tax benefits that we can help you get is certainly through the trust.
Yeah.
No greater tax mitigating strategy I've ever found.
Now, having a trust, do you have access to let's say there was an emergency for whatever the reason, do you still maintain access to the funds that are in the trust?
The short answer is yes. You have 100% access to the funds that are in the trust. The question is it going to be, if used for an emergency or for buying a boat or a car, is it going to be a taxable distribution? And the short answer is it's not going to be, whether you use it for any personal expense or any business expense. There are only 3 taxable distributions. So you still have access to it. The question is, you might pay taxes on it if it's for personal food, personal fun, or personal fashion. But through the use and through the accrual of the initial demand note when you are doing the conveyance and sale of assets to the trust, that's, like I said, a big fat IOU from the trust back to you. And that's going to be, in most cases, hundreds of thousands of dollars or much, much more. So I always say, look, you have these invisible two sides of the trust. Just code the transaction, that need that you're talking about, and have that need, if it's food, fun, or fashion, have that need come out of your demand note, that huge IOU. And by the way, some of you will invariably have a W-2 income. Some of you invariably have Social Security income. That all goes into the demand note side, or you have savings account. We're going to be putting all that money for safekeeping, so it's asset protected into the trust, and it's all going to go towards making that demand note that much bigger. And as we do that, that's going to be money that you can tap at any time for anything and have it not be a taxable distribution. So hopefully that helps.
Okay, I know Anthony, we're about to finish here, people.
Yeah, we really got to
your
wrap up, guys.
question can go, you can go ahead, give Anthony a call or email. So I have one thing for Bruce. How about if somebody has like insurance? Can their life insurance go on a trust as well?
Oh, that's such a great question. Usually asked when we get into the consult, but the answer is yes. And the trust can actually, as a trust expense, pay for the life insurance. What we usually do is we have the trust be the beneficiary of the life insurance. And this is the ideal setup. And again, we can talk about the mechanics of having that happen down the line, but that is a great utilization of the trust. And we have many, many clients that have done exactly that.
All right, thank you so much. People, you guys can save that chat. If you want to save, there's some information in the chat. Just, you see the 3 dots where it says more, you can click on it and you'll be able to save the chat yourself. But if also you want the recording, I can send it to you. But remember, you get a $250 deduction. You get it off if you schedule a call and you decide to open a trust with the company. So go ahead and give them a call. I post the information there. You can take a picture. So because we don't have time anymore for more questions, it was such a great opportunity. We'll definitely will have Bruce coming back next year. We're having a lot coming for next year. And I think in 2 weeks, we're going to have something about cost segregation, which is another, you're going to get a lot of information. Bruce and Anthony, that was very insightful. That was very informative. We truly appreciate, especially Bruce. Bruce found out last night he was coming here. And he's on vacation.
You got to be flexible, right?
Yes, so thank you so much. I truly appreciate everyone for joining. And then the next one, make sure you register for the next meeting on, I think it's going to be Thursday, the 15th, December 15th at 7 p.m. So nice seeing everybody. Thanks, everyone. Bye, Bruce. Bye, Anthony.
Thank you, everybody.
Thank you,
Appreciate
Suze.
your time today.
Thank you.
Bruce and Anthony.
Our
Bye.
pleasure.
Thank you very much.
Thank you very much.
You got
Thanks.
it.
See you on the 19th, Bruce. This is Stacy here, and we already have an appointment with you.
Oh, wonderful. Excellent. Thank you.
All right. Bye-bye.
Have a great rest of the weekend, guys.
Thank you. You too.